coming back for our second session. I'm going to turn the floor over to Cihan Artunç, who's an assistant professor at Middlebury College and a specialist in economic history and law and economics, but mostly has written on the Middle East. And he is going to talk about legal origins of corporate governance, choice of law in Egypt, 1887 to 1913. Go.
Thank you so much for this, for allowing me to speak in this conference. I'm really a little bit, I feel really starstruck, so chalk my nervousness up to that. So this has been a project long time coming. I've been working on this for quite a while. And it's still at an early stage, so I really appreciate all your questions and comments. And, in this paper, I'm going to visit this really classic question of legal origins. Are laws originating from the common law tradition more effective in promoting financial development than those derived from civil law traditions? And, the thesis is quite comprehensive, and it spans many important dimensions of law, including things like corruption. But really, the thing that I like to focus on, at the heart of this is this key view in the corporate finance literature as well, is that, this common law tradition afforded really remarkable contractual freedom to incorporators. And then they took advantage of this flexibility, adopted rules that provided stronger protections to minority shareholders, outside investors. And so as a consequence, these companies could pull capital from a wider population, leading to wider ownership structures, more active stock markets, and all the riches that come with that. So there are really two questions embedded in this debate. Stronger investor protection promotes organizational efficiency, and common law promotes stronger investor protection. I can't. This question generated enormous debate. Some have taken to this sort of cross-country analysis. Others have focused on individual countries doing case studies. And more, focusing on histories of individual countries. But there is an issue here, which is that, we want to compare companies with different legal regimes, but law and how these countries arrived at those laws cannot be really disentangled from the colonial, in many cases, country-specific histories. And the fact that, what makes this case so interesting is that the institutions and histories are bundled together, and it's really difficult to disentangle them. So I contribute to this literature by taking advantage of a rather unusual setting. And in the context of Egypt, between 1887 and 1913, ostensibly, this was and is a civil law country, but its legal environment provided extraordinary flexibility to companies. So they could incorporate under Egyptian law, which was an up-to-date transplant from France, or they could use British law, they could use any European law in theory. This allows me to trace incorporators' revealed preferences over different company laws and governance rules in the same institutional complex, subject to same aggregate economic shocks, trying to chase after the same sort of pool of investors. And this question is especially relevant in the context of late industrializers, because they are grappling with attracting foreign capital, promoting the formation of large enterprises, but they also worry about, they are suspicious of limited liability. They worry about corporate mismanagement in a place where the enterprise is quite new. And so this is why the setting itself is quite informative. So in this paper, I'm going to collect this new data set of corporations and founders in Egypt to investigate the determinants of selection into these different legal regimes. Do these different regimes affect the degree of investor protection provided in the charters? And do these protections lead to better firm outcomes? To give you a preview of findings, I find that British law broadly, not across the board, but broadly give weaker shareholder protection. And I use these different methods in order to deal with this issue. I also find that British law was associated with worse survival, especially during this enormous crisis of 1907, 1908. I also find that when you go deeper into the determinants of firm survival through governance rules, the rules that seem to have mattered are weaker voting rights, director entrenchment in the form of board rotation, and less oversight over borrowing power. And so what I find is that strong investor protection mattered for at least this dimension of firm outcomes, but investors did not seem to have, flock to companies with better rules, essentially, right? Because in terms of capitalization size, these firms are not really that different. Okay, so let me briefly talk about the historical context here. So Egypt is, okay, so it's nominally part of the Ottoman Empire, under British occupation, using French law, but people can incorporate under British law. So it's a little, there are different layers here. They are attracting a lot of European migration and investment throughout the late 19th century up to this financial crisis. And there is this artifact here, which is Egypt, as part of the Ottoman Empire, has these treaties with European powers. These are called capitulations that gave extraterritorial rights to Europeans. As a consequence of that, since the corporation is a legal person, and if you're a British corporation, then you can have British rights, like you can enjoy being British in this Egyptian context. And there is a big institutional complex that supports this. The consular courts are very well developed, right? So then you have this choice essentially between the French style Egyptian law, which was adopted in 1875. It's called the mixed courts. And these things had European and local judges. It's based on this 1867 law. It's quite up to date, except the notable point here, which is it's not general incorporation. It is still a concession system. It's not like the arduous system that, for example, Amanda outlined in the Russian context. This is sort of like an intermediate step where the government is saying, and this is explicit in the discussions from the legal discussions of the time that I traced, is that, okay, we want these companies to adopt this set of rules, and we want to make sure that they did adopt them. If you satisfy this, there's, approval is automatic. And this is reinforced by other people's writings at the time. I do have to rely on secondary sources here, but this seems to be the sort of like not quite arduous, but I don't want to say costless, right? Because it still took time, and this is something that I'm going to take advantage of. So in theory, you can use any of these European laws with which, Egypt has this capitulations treaty, but in practice, what we see is British, Belgian, and French, and Belgian and French to a much lesser extent. How does the system work? Essentially, you set up a head office in London, let's say, and you just have to maintain one employee, right, who does all the annual filings and paperwork and stuff like that. But otherwise, these are bona fide, Egyptian companies operating Alexandria or Cairo, but just subject to this foreign companies law and subject to the consular jurisdiction. Okay. There's also this economic context here, which is that there's this speculative boom. A lot of companies are getting formed in 1904 to 1906, especially. And then there's this financial crisis in 1907. This is a global crisis, actually, right? And it's disaster. Many companies are liquidated. Egypt enters into a deep recession. And after that, there's a lot of this, legal lawsuits, essentially, people trying to get, their investments back, suing all sorts of consular courts. And then the mixed courts step in and say, we're not going to allow the system to continue. They repeal this choice of law altogether. After 1908, this choice of law doesn't exist anymore. All companies have to go through the authorization process. All companies have to be Egyptian companies. The government, on their own, for their part, tightened authorization and banned, for example, things like founder shares, which they thought was very important for this like speculative boom that the bubble that burst in the end. Okay, so this was a very arduous process of getting, it was really quite laborious getting all this data. So because this is multiple legal systems going on, you have to use different sources. Egyptian law is French at the end of the day, and the charters are published in the official newspaper. That's how I got them. For the British companies, I got the charters from the National Archives. In the current version of the paper, I don't have the French and Belgian companies, but there are not really many of them. And basically, I have this beautiful list from the Annuaire de l'Espérance Égyptienne 1907, this official statistical yearbook that lists all of the Egyptian companies ever founded, primarily operating in Egypt. And that allows me to sort of like build up this data set. I know the corporations that I'm missing, and allows me to sort of build up the data set from that. From the charters, we get a lot of information. Obviously I hand code all the governance rules, but we also get information about the founders. We get information about entry, registration, the authorization date. So we see how much time has passed between people filing for authorization and then getting the charter. And all sorts of information about capital and stuff like that. The details of these variables are in the paper. I can, during the Q&A, I can go like, it's also here. But I only want to highlight a few of them for the analysis in the limited amount of time. Okay, so what we're gonna do is essentially threefold. So we're gonna look at, I'm gonna do some descriptive regression just to like trying to get a handle on how people select into these different laws, and what kind of rules that they adopt after that selection. Is this influenced by the legal regime? I'm going to use an instrument to establish some sort of causality for British law, and this is going to be the mean duration between application and getting the authorization within the 6 months of that company's foundation, excluding that company. And you can tell me in all the ways that this instrument is wrong. But this is basically like a first attempt to get a handle of, go beyond just using this descriptive regressions. I'm also going to look at the before and after this 1908 repeal. Companies that look like British companies before, what kind of rules do they adopt after the 1908 crisis, after the repeal? And then I'm also going to include controls for capitalization, industry, and repeat founders, basically the founders who appeared in at least 4 companies. There are these really professional corporation founders at this point. Okay, so this is the entry frequency and choice of law, right? So the solid line is the total number of companies. The dashed line is the number of British companies. So the residual are the essentially civil law companies, right? And not a lot of corporations before 1895. And then you can really see this boom happening after 1901, right? A lot of companies are being founded. The vertical line here is the crisis, the 1907 financial crisis. You still have some companies being formed, right after, but then in 1908, it stops, and then you don't see British companies afterwards. Okay. So let's start with some of these descriptive regressions. What I see here is these are OLS, so using linear probability models. The dependent variable is a dummy for incorporating under British company, under British law. And what we see is that, capitalization, not really that different between British companies and Egyptian companies, which are, as I said, French law. The biggest predictor of being incorporated under British law is the proportion of British founders. That seems to be really, really explaining a lot of the selection. And also people are, responding to the decree delay. So this is measured as in number of days, right? That means each additional day people wait that year to get their charter authorization, a company is 1.3 percentage point more likely to have incorporated under British law. So that means if other companies have waited for a month, then you're 40 percentage points more likely to incorporate under British law. So people are actually responding to these wait times. If you look at the sort of individual rules, for example, in terms of founder shares, these companies are not really that different from each other. Looking at the Hill's voting rights index, where again, 1 means 1 share, 1 vote, 0 means something closer to 1 shareholder, 1 vote almost. And we see British companies much more likely to adopt 1 share, 1 vote. British companies are much more likely to include these fixed quorum rules, where any fixed number of members become a quorum in the general meeting. In terms of making it harder to call an extraordinary general meeting, these laws are not that different. In terms of director compensation, they are not really that different. In terms of board election, British companies are much less likely to rotate the entire board in the first election. So the board members are a little bit more entrenched compared to the French companies. The British companies are much less likely to include any restriction on borrowing and Egyptian companies are more likely to include it with some restriction. But the British companies are better in one thing, and that is communication, it turns out. They are more likely to send out these financial reports before a general meeting, whereas Egyptian companies say, well, you got to pick them up from the head office, right? So it's not, British companies are not sort of worse across the board in this sort of governance rules. And then we can look at the, the firm survival across these different legal regimes. And what you see here is a Kaplan-Meier survival estimate for companies incorporated under British law, companies incorporated under Egyptian law before 1908, and then after 1908 when this repeal happens. And you can see that Egyptian companies are just significantly more robust compared to the British companies. You can really zoom in on using accelerated failure time models, or do some sort of like OLS where it takes a value of 1 if you survive the crisis of 1907. And again, like however you cut it, British companies seem to do a lot worse. If you zoom in on specific governance rules, it seems that voting rights matter the most. So Hill's voting rights index is quite important here. So these companies, this is accelerated, these are estimated failure time ratios. So this means a company with 1 share, 1 vote leaves 50%, has 50% less duration before failure compared to a company whose Hill's index is closer to 0. And then you see that board election also turns out to be quite important. Borrowing restrictions turned out to be quite important as well. So let me conclude here. In this paper, I try to take advantage of Egypt's legal flexibility to trace founders' revealed preferences and disentangle some of these effects from the effects of legal origins from governance rules and etc. And the evidence shows that these companies looked like each other in terms of size and industry, but there's a bifurcation of rules in the sense that British law companies tend to adopt a given set of rules. Egyptian companies took up a different set of rules. And these rules seem to have mattered. Were they important in raising capital? I don't think so, but the evidence is somewhat more descriptive. I can only compare nominal capital, but this might explain why the French law might have been better in affecting firm survival, because the founders did not really take advantage, not adopt these rules. And so when you have this prescriptive law stepping in, because shareholders don't seem to have cared, it did affect survival. And in the future work, I'd like to complement this with more data on balance sheets and dividend payouts, which I'm collecting right now. And so I will stop here and start taking questions.
Thank you very much, Cihan. Well, we actually have quite a long queue, but before you get to the queue, Marco had a quick question in the chat, which is informational, which was about, could you just go over the attributes quickly of the founder shares? And we have a long queue, so so just I'll let you do that briefly, and we'll go to the queue.
Thanks for that question. Founder shares are, that stirred quite the debate during the period. Essentially, these founder shares usually, not always, but usually did not have any voting rights at all. They are issued at the time of the company's foundation. It could not be issued after. They had no par value, so there's no liability associated with them. And the idea is that, okay, this company is going to be so profitable. If you want to get it on the, at at ground zero, like you need to buy these now. We will pay extraordinary profits. These are going to be so profitable. These are going to be great. And this is what the government thought, that companies were sort of promoters, were taking advantage of like a exuberant public, essentially. There's a lot of disagreement about it, but like, in the analysis I did find them to be quite important in explaining survival.
Thank you. Okay, first, Mohammed.
Okay, thanks, Cihan. That's fascinating. So I have a couple of questions. First, about like some historical details that I just want to make sure I get right. The first one is about the eligibility conditions for incorporating under laws that are different from the French law or the Egyptian law. So you say in the papers that it was open to both Europeans and Egyptians, if I understand correctly. But does that mean that it was open to everyone literally, or was it only like based on the nationality of founders, like that you have to be a European or a protege, or to have one or at least one founder on board who's European in order to incorporate under a different law? Mm-hmm. That's my first question. Second question is, it was not clear to me like why there are corporations that incorporate under French law. If the Egyptian law is already a transplant of the French law, then what are the additional benefits from getting or selecting into the French law? My third question is about interpreting the results. So I was thinking that there is an issue here with the British firms, in the sense that Britain had it was a colonial power, right? Mm-hmm. So I'm wondering if there is some element of adverse selection of British investors, during this period, and they choose to incorporate under British law in order to avoid, some of the hurdles of the Egyptian law, and then it's kind of like being negatively selected, essentially, these investors. Yes, so these are my three questions. Thanks.
Yeah, that's great. Thank you. So these are the questions that I'm struggling with as well, trying to understand. In terms of eligibility, you can incorporate under British law, even if there are no British people here. But it doesn't mean it's less. It's like people will incur the same cost, right? It is. I mean, it's definitely. I can definitely see it plausible having a British person making it easier to incorporate, because like maybe the people, you can set up the office. You still need to set up an office in London, right? It is probably much easier to just get like one British guy and have that person be the employee. And I do see this in the charters, right? They get like one clerk who's a founder, and the clerk is like files the incorporation charter. And then, it's basically you have like one British person in the founding group. And then later this person doesn't even appear in the first board of directors, right? So you can, like, I do see things like that. In terms of like the French or the Belgian ones, it's a little bit more unclear. I think the French do require a person to be French in order to incorporate. But also, this is building up to your second question, which is that, like, why incorporate under French law? Why indeed? I mean, I don't see a lot of French companies anyway. Actually, I do want to emphasize that. There are some Belgian companies. I don't have all their charters, so I can't really make comparisons. The Belgian charters that I did find are not really different from the Egyptian ones that I found. And the law, especially the Egyptian law at this point, is pretty close to the 1867 law. And this might explain why we don't see a lot of French charters to begin with. Interpreting the results, yeah, I mean, there might be some sort of adverse selection here for sure. This is why I try to like look at some of the, what's going on with these companies after they have to incorporate under Egyptian law. There does seem to be, like if you look at that Kaplan-Meier estimate that I showed earlier, they do become more fragile, after the repeal. So that supports the adverse selection story a little bit, but it seems like the law still has like some bite here that I'm trying to get a handle
on. I just had two quick thoughts. One, yeah, I don't think your findings really depend on the instrument very much, if you look through them. But I'm not sure I really, conceptually buy that instrument. I'll just put that out there. I did wonder why, or say you could, you have a relatively small N, and I was wondering whether maybe more of a matching framework would be reasonable in this setting. Just given that you're really concerned that being British gets you, other stuff, or, there's some substitution. You get some, you go to parties in London, and therefore you're willing to give up profits in Egypt or something like this. So being able to try to at least, siphon away some of the unobservables through a matching framework might be useful. Random thought.
Yeah, I can try that. I'm trying to build up like a synthetic control group. So we'll see how that goes.
You've somewhat answered this question already, but I'll ask it a different way, and maybe this may be a result of my misunderstanding your context, but to what degree do you think of these corporations as participating in the same capital market, or are they really thinking about getting investment from different sources? Because it seems to me, whenever we have this issue as well, like if there's an observable characteristic of a company name that's visible to everyone, and you can, as an investor, start to associate British companies, like, that they fail more, why invest in one? Are they communicating with a different audience? Just, you answered that, you said something about this in answer to Mohammed's question, but how do you conceptually think about that?
So this is something that I've been pondering quite a bit. These companies, most of them are not listed at all. So a lot of this is going through private finance, right? My impression is also that these firms are trying to use different strategies. So definitely you see these British companies promoting in, publishing their memoranda in London gazettes, but also in Egyptian gazettes. I think they're trying to sort of do both. I am not entirely sure, right? Like how much of this is different, and how many of them are trying to select into these different capital markets. It's hard to say. I find it very plausible, right? I find it really plausible that British companies are trying to select into, are incorporating under British law in order to go to the British capital markets, right? But a lot of Egyptian law companies do the same thing. But this is why, if you look at the historical record, the discussions, which I read quite a bit, they claim that, okay, like we can't repeal this choice of law. Like we need to be a British company in order to go to, go to the British capital markets. But also they're trying to keep the system. So, of course, like they have a stake in saying that. So if you have suggestions on disentangling that, I'm all ears.
So this might be a version of the questions that have been asked, but I was wondering about whether you had some information on how the companies, to start with, were different, the companies that incorporated under different laws. So I was struck by the different failure rates. And I keep thinking, there might be initial differences that might explain that. And I was wondering whether you could say something more about this.
Right. So this sort of comes back to, I think, Mohammed's question about adverse selection too, because like if I look at the observables in terms of industry, capital, like the things that I can actually get from the data, they are really not that different. Capital does explain failure. So if you're a large company, you are less likely to fail, which is not surprising. But otherwise, in terms of other things, it's, the things that I found to be not causal, but correlates of survival are the fact that whether you're a British company or not, right? And also whether you have this like other governance rules that seem to have affected. In terms of, I found this quite surprising, but, I didn't see the sort of, like industry differences are not really, except in mining, really are not that salient. and neither is capital.
Cihan, thank you for this very interesting paper. I have a suggestion that's closely related to Steve's comment. I think you do have this very nice sharp break where all of a sudden the option of incorporating under British law is taken away. And you're using that, but I would sort of suggest a different way to use that a little bit more strongly. And that is, what I think you might want to try to do is identify a group of companies that almost certainly would have been incorporated under British law, but were not able to. And so, you have this very strong prediction where if you have a lot of British people who are founders, like they're choosing British law. So comparing firms after 1908 who would have chosen British law, but were unable to this very, very similar firms incorporated right before 1908 who had that option. Like the difference in outcomes you observe subsequently of those two groups of firms can be plausibly related to that cutoff. Now, when you lose British law, you lose this whole bundle of corporate charter provisions or rights and so on. And so you're seeing the effect of all of that together. But I think that's a really nice way to potentially see the effect of that change.
Thanks for that comment. Yeah, like this is something that I definitely want to pursue. This is what I had in mind when I said, like, maybe not I guess it's not a scientific control group, it's a scientific treatment group. Something that I'm, really looking into. I try to do basically that, like a more primitive version of this by using the proportion of British founders after the repeal. It gets at that somewhat, but I can do a much better job in that. And so thanks for that suggestion.
Ron.
Yeah. I really like this project, and part of my question was already taken by Giuseppe. The other part is, when you look at the different elements of British law, which of them were mandatory and which of them were default, in the sense of which of them did you have to take as part of the package of being British with all of the side benefits, etc., and which of them could be played differently by different incorporators and different firms in a manner in which you could actually distinguish the decision-making of the incorporators?
Yeah, so that's a great question. Perhaps it's not surprising, but British law is not really, prescriptive, right? And so I think it did afford incorporators with, more freedom. They just ended up in this group of like, okay, we're gonna do one share, one vote, fixed quorum, and like not a lot of difference there. The French law was prescriptive. The prescription is that, yes, we are going to have, these rules about like, if you want to have an extraordinary meeting, you do have to have like this 3/4 rule of, for quorum and stuff like that, right? And there is still the authorization process, which is, again, it's not arbitrary, but they do say like, we want these rules to be set up. And I think in the French case, like it is really, you are buying into, when you select incorporate under Egyptian law, you are buying that package, which is that we're going to have graduated scale. We're going to have a quorum rule in which we're going to give, we will require a % of the share capital to be represented. Like these things do come in. And it's what makes disentangling these things from each other really quite difficult. But it sort of comes into, I think, like Amanda's and Steve's and Amy's paper, right? In the sense that like there's no law there, in the sense, like they're all under Russian law, but you have the A Corp and the share partnerships, which sort of are sufficient statistics for different things. And this might act up in the same way in this case, in the sense that, when you're a British company, people immediately know what that company looks like. And when you say we're a French company, again, people know what that looks like. And I think that's part of the story too.
So there is a queue, Marco, John Turner, Les Hanna, Bill English, Maddie Zellen. And we'll go to Marco now, but there's also a question in the chat that maybe you could work into one of your answers, which is about whether companies are really too big to fail. Okay,
Yeah,
Michael.
thank you, Naomi. So my question is really related to the sources of finance. And if you think about the modern equivalent, I mean, we have, of course, under Centros, Germans who go to the UK because they adopt the limited because it's very cheap, it doesn't have minimal capital, and then the failure rates are very high. Or you could have people going from Egypt to NASDAQ because it's the bonding and they want better law in order to raise money in London. Or you could have people in France who incorporate in France, raising money from a French bank to then go to Egypt to set up essentially a colonial enterprise. So I'm not quite sure whether, which of these three or another possibility you're really capturing. And if it's really the price of law, so going for the cheapest law, if the English law was the cheapest, well, you have the cheapest kind of product, and then your failure rate, is related to that because they're actually not trying to raise any money. They're just trying to get the cheapest possible legal vehicle, and then they all fail, of course, especially if they use things like these founder shares, which seem, well, interesting.
Yeah, so a few points. First of all, the founder shares, I mean, before 1908, the Egyptian companies were just as likely to adopt founder shares, and the ones that did adopt founder shares also failed, actually. So there's that. But I take your point about the costliness. I mean, people did definitely respond to the costliness of the authorization process. So the British law in many ways could be less costly, especially if you already have like a critical mass of British founders. In terms of the financing, so Egyptian is a sort of semi-colonial enterprise, right? And you have this, you don't need to go to a French bank, like the French have their bank in Egypt. And so you go to that bank. And all these like Anglo-Egyptian banks, and there are all these, Crédit Foncier, all sorts of like mortgage banks, land banks. Actually, the Egyptian financial system, I don't want to say like developed per se, like let's not get too ambitious, but it is better than a lot of other developing economies at the time. And even if you discount Egyptian debt, the size of the Alexandria and Cairo stock exchange is actually, it's not enormous for anything, but it is it is bigger than the Ottoman Empire, of which Egypt is a part of, right? So in that way, like there are a lot of European investors here. There's a lot of European migration going on. So from my readings of the legal disputes during the in the aftermath of the 1907 crisis, it looks like a lot of investors are in Egypt. But it is anecdotal, so take that with a grain of salt.
John Turner.
Thanks, Naomi. This is a wonderful institutional setup, and I really like what you're doing in this paper. Just one sort of question in terms of to clarify things. So you state in the paper that preference shares have no voting rights, but in the UK context, at the very same time, you would have seen preference shares that had no voting rights, preference shares that had conditional voting rights, and preference shares that had the same voting rights as ordinary shares, or preference shares that had half the voting rights of ordinary shares. So it's puzzling that you don't see that variation. And then the second question I have is, what happened when things went wrong? So particularly with one of these British constitutions, so one party didn't live up to one of the articles. What happened? How were they enforced? So again, thanks for a really interesting book.
Yeah, great question. Thank you. Yeah, look, you're absolutely right about the preference shares. After 1908, there are not, to be super clear, there are not a lot of companies with preference shares. So hard to, I really shouldn't have extrapolated from the observation that I did have. Later, I have this data going after, until 1950, essentially. So that's going to be a different paper, different question. But there, I do see companies with preference shares and voting rights associated with those shares. So you're absolutely right. So that appears even in the French context later on. So I'll make sure to correct that. Yeah. So I after reading these legal disputes quite a bit, my impression is that if there's this, you want to sue this company, you go to the consular courts and then you sue the company in that court. That's where you make the application. A very valid concern is that like just how sophisticated are these consular courts, and my impression is that my dissertation was on this topic, right? They are quite sophisticated. You know, this institution, this consular court, existed since the 1700s, and so they have experience in dealing with this. They are developed to support this sort of events, right? And the reason that the mixed courts like stepped in to repeal this choice of law in the end was that, well, you know, if this consular courts make a decision, there is not a lot of room for appeal, because now in order to appeal, you do have to go to London or something, right? And that's the issue that they raise, is that like, if you are an Egyptian company, you should not be like, people should not have to leave Egypt in order to sue you. And so that was the main source of objection when they in the end repealed.
My camera seems to have cut out, so you'll have to do with my voice. The question of failure, what does it mean? A lot of people are now using failure as a measure of performance because it seems so clear, but I'm not absolutely sure it is. I mean, for example, one of the findings is that failure is much more common in this period on the New York Stock Exchange than on Paris, Berlin, or London. It didn't matter a bit, because failure on the New York Stock Exchange meant investment bankers, managers came in and just reorganized the relative rights of bondholders, common stockholders and preferred stockholders. What is happening in Egypt in 1907? Is this just a reorganization of rights of founder shares, preference shares, bondholders? I guess you don't know all this because you've not actually looked at the balance sheet yet. So you don't know whether allowing a lot of leverage led to their actually having a lot more leverage and thus failing in this period. But I think it'd be more convincing if you could, if these are just being reorganized into a firm of almost the same kind, it may just be one type of shareholder that's losing out, not all the investors.
So I think so that's a great question. Thanks, Leslie. I think I can address this concern. These are not reorganizations. These are failures.
These are disappearances.
They disappear. I control this through several ways. One is that the exit date that I'm using is the date in which the shareholders approve the articles of winding up. So they have the extraordinary resolution. They're saying we are winding up. They're not saying we're reorganizing. We are winding up. Okay. And then I see, you know, since I have all the charters, in the charters they say, oh, we're taking the assets of this company. So I control for that. Like if a company is reorganized, and there are a few reorganizations here, I do not consider them as exits.
Right, thank you. So like everybody else, I thought this was a terrific paper and a really interesting case to look at. I wanted to talk just a little bit more about the choice of British law. So somebody asked earlier about whether you chose British law if you wanted to raise money in the British financial markets, and I wondered if you chose British law because you wanted to engage in trade with Britain, and that was easier to do if you were a British company, at least kind of reputationally perhaps, and that could also have implications for failure after the 1907 panic, and so maybe that's part of your story. I don't know this history well enough, but it seemed a possibility. Thanks.
Yeah, this is a great point. And you know, I agree with that in the sense that you know, the crisis was precipitated by the constraints, by the constraint condition. Really, the British capital markets appeared at the time, and to the extent that these companies are connected to the British capital markets, they suffered more, right? So that's the sort of, again, like descriptive evidence that I'm getting from like reading the you know, contemporary news articles at the time. You know, these companies again are not listed, right? Most of them are not listed. This is private financing. But my impression that a lot of them, I mean, they could, like, I believe that story, they could be going to the British capital markets and raising their capital there privately. I find that sort of plausible. By reading, also it seems to be a lot of these investors are actually in Egypt too. I mean, you know, this is sort of the situation that I'm at. If there is a source that I can pursue to make this point a bit clearer, like I would love to do that. Like, you know, this is why I got invented presentations, right? So that I can take advantage of the collective knowledge of this brain trust.
Yeah, maybe another angle at the same issue would be if there are British firms that chose British law, but which chose, I mean, they had flexibility as you described.
Mm-hmm.
They chose to provide good investor protection. Were those firms that then survived? So you know, maybe they had similar exposures, but they just structured themselves differently, and that was helpful for them. That'd be interesting to know as well.
Yeah. So that's a great point, and I think this is what I'm getting at by, you know, in these survival analysis that I do. When you move away from like whether you're a British company or not, and you know, look at the specific governance rules, like those rules, the rules themselves seem to have mattered. Not all of them, but several of them. And that seems to suggest that even if you're a British company, if you have this like better, you know, if you scored lower on the Hills index, right? I mean, that you were more likely to survive. So it seems that the stronger investor protection seems to have mattered. Yeah, independent of the law.
We have one last question that we have time for, which is by Maddie Zellen. But there are a couple of questions in the Q&A. So let me just tell you what they are. Maybe you can work the answers into your answer to Maddie. But one is, does the choice of British law relate to Egyptian investment in Egypt, i.e. round tripping? This is from Mira Wilkins. And then from Hari Pandey, was 1907 connected with World War I events? So I'll leave you to work it in answers to those questions, but here's Maddie.
Yeah, I think actually Mira's question might somewhat fit into what I'm interested in, and it's not surprising that I'm interested in you seem to imply that a lot of the people who are doing this investing are Egyptians. Mm-hmm. And then the question emerges, and it doesn't really come out. To what extent are these people making choices based on what they understand in their own kind of indigenous context as the way in which business should operate? In other words, to what extent is custom driving them in one direction or another?
Yeah, so I thanks for that question, Maddie. And you know, like reading your paper is actually like a lot of the issues that I really care about. So you know, it was really interesting to see the parallels. I do want to clarify, but I do say Egyptian, but like a lot of this, by Egyptian I mean like people living in Egypt. These people, I think most of them are still European investors, expats, migrants, whatever you want to call them. So there are, you know, Egyptian people who are founders, like quite a bit of them. I'm not sure they're all shareholders. Like a lot of these cases that precipitated during the 1907 crisis and the lawsuits afterwards. Like if you look at the names, it seems to be a lot of like Italian and Maltese and Greek migrants. And but that doesn't mean like there are other, you know, perhaps like other Muslim investors as well. I mean, I don't know. Unfortunately, I don't have a list of shareholders. It would have been great, you know, that would have been my dream data, but I simply don't have that. In terms of indigenous practices, you know, this is actually very, yeah, it's a very interesting question. It's, like I have to ponder on that, and it's like it's a whole other paper.
No, but we don't have any more time, but I would say it's extremely interesting, in particular in light of things like Timur Koren's, you know, arguments about the Waqf and so on. And to what extent are people trying to choose, perhaps choosing not to form their companies under these two alternatives because they don't fit their indigenous practice? So if you're going to take it further, I would be so interested in knowing that side of the question.
Yeah, thanks for that. And just to fire off, like if really quick answers for the Q&A. I don't think the 1907 was related to the World War I events at all. The 1907, the crisis I'm talking about is the crisis that happened in Britain, in the US. It's sort of all related. It's a global crisis that might have precipitated World War I events in some way, but that's a different story. And the choice of law, of British law related to Egyptian investment in Egypt. Yeah, so this is how they justified it on the ground, saying that we need to have this British law, we need to have this Belgian law, we need to do these things in order to raise capital in these markets, because they are not gonna, like, they don't know Egypt, like they literally say this, right? They don't know Egypt, like, oh, like what kind of law is that? But actually the people did know. And there are Egyptian law companies kicking around in London or Belgium or whatever. And after the 1907 crisis, you have this confounding factor, which is that because of that crisis, capital markets sort of dry up and you just don't see a lot of investment afterwards. So I'm sympathetic to that point, but I'm not sure with the data that I have, I'll be able to disentangle that effectively in a way that I can make a confident answer.